It's always difficult to, when you're asked to introduce yourself and to give your bio. I prefer calling myself Otto. I don't like to be called Mr. I know many people tend to do that. Otto is enough. I happen to have gone to law school. I don't call myself a lawyer, but I passed through the law school. And have really been fascinated by issues to do with technology, law, data protection, of which I had a second master's in law, which was focusing on this. I'm currently also researching on data protection laws in Zimbabwe as a doctoral student at the University of Western Cape. In my day-to-day living, I work for the Ford Foundation as a global program officer on civic engagement and government. But I'm not here to talk about my employer or my employment. And those two things are not related. So for a start, you might have heard from the colleagues from Fortress. The issues that we're talking about on data protection are quite complicated. They're very complex. And they're fast moving. So you might have seen in other parts of the world that after passing a law, they might go back and revisit because certain things would have happened. New technologies are coming up day in, day out, which are challenging the way we interpret these laws or understand them. So there is need to be very flexible and to be very adaptive when we talk about these issues. With the guides that we produce, it's basically an attempt to simplify what you have in the Cyber and Data Protection Act. So a few things to take note of. It's not exhaustive. If we had wanted to make it exhaustive, we would have ended up with a handbook, which could have been very, very intense. It's not also intended to give legal advice. If you want legal advice, please look for your lawyers and get legal advice. You cannot cite this and say, by virtue of the MISA guide, we are making a legal decision. No, it helps you to understand or to have a better appreciation. And as well, data protection is not only about the law, which is why I appreciate the colleague who raised the technical and the engineering related aspects. The Act itself speaks to technical and organizational measures, which might include what others call privacy-enhancing technologies or transparency-enhancing technologies, which includes, anonymization, pseudonymization, encryption, you name it. So you need to have others involved in this. So it's a multidisciplinary issue. So let's not let lawyers dominate. I know I'm one, but it's important to have all disciplines involved because this is a multidisciplinary issue and it affects a number of issues. Second, I also try in the guide to give some examples of the concepts. So what do you mean when you say personal information? What do you mean when you say a data subject? What do you mean when you say a data controller or a data processor? The guide also follows the structure of the Act. I know that there have been, there were a number of concerns. I still have a number of concerns with the Act as is. Some of it I think has to do with the drafting related aspects. That there were a number of omissions and oversights that were there, but also that the structure could have been done differently. So we try to follow the structure of the Act in the guide, so that as you read the Act and read the guide, you are following section by section. There is some consistency in there. There's also reference to other standards, and other standards here I make reference to the Protection of Personal Information Act of 2013, the South African one, called POPI in short. I also make reference to the European Union General Data Protection Regulation, GDPR, which has become or is known as more or less the global standard, but that's also debatable. I also make reference to the SAHRIT model law on data protection, which is, as Ms. Mario mentioned, under review It's a model law, it's not the law, and there are two different things of that. So that's what the guide tries to do. This history has been narrated a bit already earlier on, but I think it's important for us to restate that the making of the data protection law started off with the Harmonization of Information Project in Sub-Saharan Africa, HIPSA, which was a project under the EU and the AU. If you look in other jurisdictions, similar processes have happened. In South Africa in particular, they produced, I think it's almost 200 plus, sort of a document by the South African Law Reform Commission, which was looking into the processes of developing a data protection law, which is their copying. Then we had a number of layman's drafts that were in circulation. In 2018, there was a Computer and Cyber Crimes, which also was informed by the SAHRIT model law. Then we had Data Protection Bill in 2018. Then 2019, we had the Cyber Security and Data Protection Bill. Then eventually in 2021, we had the Data Protection Act. A couple of things happened in between because of the consultations. There was removal of security on the act to make it a data protection. Then it was passed as data protection in December 2021. Then in March 2022, this year, there was a notice of correction of the title of the act, and it became the Cyber and Data Protection. But I'm also concerned that in the corrections, there were a number of things that were changed which were good, but there were also others which might be concerning. An example is the objects of the act itself. So section 2, in the data protection of 2021, the object of the act was to increase data protection. But when the changes were made, it came to increase cybersecurity. They might sound very related, but they're different. And I think it's important as we interrogate the interpretation and the application, what those implications are. A focus on increasing cybersecurity and a focus on increasing data protection. My inclination is to interpret from a human rights perspective because that's where I started my work. So when you talk of increasing data protection, you're focusing on the data subject, you're focusing on the rights. The moment you take a cybersecurity dimension, you are putting almost everything in there, which might include your national security, your public interest, etc. And that has been the tension with many laws on data protection, that they sort of then conflate data protection with national security and national interest, which are different two things. But that's an aside. There are also other laws that I think might be in the making. I'm not so sure, I haven't followed closely, like the electronic transactions in e-commerce law. I think we need that because the laws that we have right now are not sufficient to deal with electronic commerce. If we are moving into the implementation of NDS 1, I think that is necessary. Then also the sectorial codes and codes of conduct and guidelines. That is going to be needed. The Act itself speaks to that, and it empowers the Data Protection Authority, in this case, POTRAS, to be leading in those conversations. Just moving on, because of the complexities around, I need to go back here. There was an issue that came up, I think it was Maimari who mentioned it, that some groups or individuals were now reporting cases of data breaches that happened before the Act. It's unfortunate that has been the case because I think we make an assumption that before this Act, there was a vacuum in the law. I personally don't think there was a vacuum in the law. There probably was a vacuum in awareness from the service providers, from the data collectors and processors. By virtue of common law operation, privacy is protected, was protected, even before the 2013 Constitution, which introduced the right to privacy, because before then we didn't have a specific right to privacy. There was protection of expression of personal information, communication, but not necessarily on privacy. So before the Data Protection Act, I would argue that there were laws to protect. Some of them might have been contractual, a consumer to a service provider. That relationship creates grounds. Some of them might have been statutory. The collection of your information when you're registering for a SIM card, there are provisions in those statutory instruments that actually create certain obligations on the data controller in that instance. But there's also a major issue that we have to deal with in this country, which is the trust deficit. And on this, I'm going to pick on Potras for a minute. You might have recalled that at some point, I think it was the 2018 elections, there was an issue around individuals receiving SMSs on our phones. And one lawyer took that to court. And there was tussling. I think Potras, the Zimbabwe Electoral Commission, mobile network operators. Up to now, I'm not so sure who was liable. But I can safely say all of them were jointly and severally liable for that. Because when information, and I give my information I'm registering to a service provider like a mobile network operator, I'm giving that in trust. For purposes of me getting a service, which services I need data, I need to get SMSs that are relevant for what I would have consented to, I need to do voice calls. I did not consent to then getting these extras that you are giving me. The same as for ZEC. When ZEC collected the information for the voters' roll, it was very specific. It's for me to appear on the biometric voters' roll. It is not then to allege that another political party or other political parties have had access. They failed in their responsibility in terms of the Electoral Act to actually safeguard that information. That's the point that I'm driving at. That in as much as we didn't have a comprehensive law, which is what we have right now, the sectorial and subsidiary laws that existed were sufficient and are still sufficient to enforce your rights as a data subject. Case in point, if your banking information had ended up in the public domain pre this act, what were you going to do? Say there's no data protection law? Certainly not. The Banking Act provides that it's the responsibility of the bankers to keep your information secure. So there's no vacuum. There was never a vacuum, but there might have been a vacuum insofar as the regulation and the enforcement is concerned. I've touched briefly on the objects of the Act. Then the application of the Act. The Act applies to both public and private data collection. And I think this is important for us to take into account. We can have a substantive discussion around other public data collection processes that are taking place in terms of other laws where there's no sufficient oversight because of interception, national security, etc., etc. Then the compliance was effective from the date of gazetting, has already been said. I've already touched on the issue of existing laws that we need to take into account briefly. So moving on, what are some of the key issues that we cover? What is personal data? What is personal information? How do we define that? And how does the Act define that? So personal information relates to a natural person. Natural, it's, this natural person. But there are also instances where it can apply to a juristic person. And what do we mean by a juristic person? It might mean a company, it might mean an entity that is formed at law. An example is, if I form a company and I'm the sole owner of that company, it will be difficult to separate my personal financial information and banking information and records from that of the company. So you can actually apply to a juristic person who is a company. Otto Saki Holdings with an individual owner is a juristic person, but the information of that juristic person is not different from the information of the natural person who is the sole entrepreneur. So we need also to be mindful that while the Act is talking of natural persons, it might actually be applicable to juristic persons when we interpret it. So those are some of the examples of what personal data is. I know right now IP addresses, there's a move towards producing what are called dynamic IP addresses, right, which are automatically populated and generated, which might not necessarily identify you as a very specific, But when you do make your payment, it will be very easy to see who was operating on this. There are unique identifiers that you have. Your ID number is an example of that. You know, your date of birth, your mobile phone, GPS location, geolocation. We all want to send where we are on location. It's actually personal information. Insurance details. So the list goes on and on. You know, in terms of what that information is or it shouldn't be. I think another point, before I forget, also for colleagues at Portras to note, is the definition of personal information in the Cyber and Data Protection Act and the definition of personal information in the Freedom of Information Act. There's need for us to find ways of sort of reconciling those, you know, definitions. And the reason is that Portras plays a dual role. You are advising the minister also on Freedom of Information Act, which I have on right access to information, which I have difficulties with because there is a Zimbabwe Media Commission which is dealing with access to information requests. Ordinarily, they should have been the one who are advising on the freedom of information. So that's another point in terms of this act that, you know, we need to look at going forward. Another area that is important is what is a data subject? So when we say a data subject, what do we mean? A data subject. We've already said that there's a natural person or a juristic person. So a data subject is an individual from whom the data is collected, directly or indirectly. Hear me well on this one. And in the guide, we really try to explain or give examples. Information can be collected directly. Directly is when I come to NOMPILO and I give NOMPILO a form or an application and say, I need your name, your address, your date of birth, your ID number, maybe I might need even your blood group. If I'm in the insurance or medical, you know, I might need your history of, you know, other operations or, you know, chronic illness that you might have. Right. So I've approached a person, I've approached the data subject, and they've given me the specific information. So all the information that I'm collecting directly. But you might decide as Telecel, sorry, I'm going to pick on Telecel because you're right in front of me. You might decide as Telecel that you want to have a customer survey, but you are not going to do it directly. You are going to contract Research International to do a customer survey on your behalf, right? They are collecting information directly for you, but as a processor on your behalf. And the information is coming to you. They might also decide not to collect that information directly from NOMPILO and do it indirectly. How? They might go into public databases, they might do data mining, they might do web crawling, they might do secondary sources, but that information is personal information, only that it has been collected indirectly. And the issue that I think we need to be familiarized with in terms of the Act on the implications of where you collect directly, where you collect indirectly, what is the consent level, what is the law authorizing that. Bringing me to the second point, that data is not only collected because of consent. And there are a number of examples where recently the law action was compelling consent. With COVID, you might have refused to be tested or to give your PCR test result, but you were compelled to do that as a matter of law, though that information might have been personal medical health information. Or you are employed contractually to fulfill certain obligations. You have to provide that information. So you can't then say, oh, because there's a data protection law, I'm not going to give you, you know, my information. The Act specifies legal circumstances in which you have to give, give the information. So some of the data subject rights that the Act talks about and that we cover in the guide includes the right to be informed. So when you're asking the information, or collecting the information, you have to tell me as a data subject, I'm requesting to collect this information for these reasons. So I should know. It shouldn't be guesswork. Or to then be said, oh, by the way, we collected. And there's also another thing that we need to be, conscientizing. There's a lot of fine print, mobile network operators, insurance providers, medical service providers, bankers, all of them. A lot of fine print that if you don't read it carefully, you'll be surrendering your information, and when you then object, it's then pulled out. And I think this is also the responsibility of portals, and I've seen it globally, where there's a simplification of terms and service of conditions to make it simple. You put it in fine print. Some of us who wear glasses can't even read, or those that who have visual impairment cannot even read. Right? It's not even translated. It's not even played on the website that these are the things that you are signing up to. So I'm not informed in that instance. I can actually object that I have not been informed because it's not clear, it's not unambiguous, it's not very specific because it's written on this final print. Then you also have rights to access personal information in the custody of a data controller or processor. And this is part of enforcing the right to privacy. And I mentioned earlier on the Zimbabwe Media Commission and portals and their responsibilities, which might be problematic if not coordinated. So, if you know that Econet is holding your personal information, you can actually make a request to say, I actually want to see the information that you're holding. Right? We know for those that are on social media or on Facebook, that platforms such as Facebook have got so many data point collections. I think the last time I checked, we did about 98 data point collections about you as an individual. 98. That helps them to get to know the different aspects and attributes about an individual. It's not just your name, your date of birth. It might be even your acquaintances, it might be even your engagements, it might even be, so many things. So in that instance, you have an opportunity to actually ask, what is the information that you are collecting or that you are holding on my behalf, my information, because it's your information. But there are also challenges with this, and in Zimbabwe in particular, in many other jurisdictions, because you have other laws that are allowing for collection of information which do not have oversight provisions. And one of them is the Interception of Communications Act. We know that information is being intercepted, information is being collected, but we know that there is insufficient oversight. In South Africa, there was a decision, the Ababungani case, where basically similar provisions in their regulation of Interception of Communications Act were struck off as unconstitutional because they were giving so much powers to the authorities. Even here we had a similar provision, I think it was the Postal and Telecommunications Act, that was struck down by the Supreme Court, must have been 2013 or even earlier, on the basis that it was also giving the executive so much powers. So I see that happening with the Interception of Communications Act at some point. You also have the right to object to processing. So if someone objects to processing, don't scold them with I'm not you're too much manning. It's their right. Explain to them why they have objected so that they understand what you're trying to do. And not label them as difficult customers. There also is the right to correction of false information or misleading information. And that is important for data subjects. You might say that false information is fine because it's not disclosing you who you are. So as an example, if my name Otto is given another surname, or my name Otto Saki is given another ID number, not the one that I have, I'll probably say it's fine. But maybe when it comes to claiming of insurance, someone else might actually be able to impersonate me using that number and claim insurance. So I would have suffered economic harm. Or you might say that it's fine if my medical records are kept confidential but are disclosed with pseudonyms, etc., etc. But there might be something that then leads to the identification of you as a person, which might lead actually to discrimination or stigma. So it's important to have correct records. And it's the responsibility of the controller, but also of the data subject, to make sure that the information that is being held is correct. The same example applies with voter registration, which I think is being talked about right now. It's your responsibility to actually see that your location is correct on the roll. The Electoral Commission will only say, we're inviting you to inspect, but they're not going to come to your house and say, have you inspected? That's your responsibility. It affects you when you then want to exercise your right. There's also the right to deletion of false information or misleading data. And I think this is very important. One missing provision in the Act, I'm going to be putting some missing provisions or difficult provisions that I have from my own view. I don't think it might represent MISA, but if they want to be associated with me, then that's fine. Is the right to data portability. I think this is important if you're talking of a digital economy. So data portability basically allows individuals to obtain and reuse their personal data for their own purposes across different services, right? In the mobile network operator, you talk of interoperability, or saying that you can actually take your telecell number to Econet. You then remove just change, what do you call the first three numbers? Those, are they prefix or something? So 077, then I move to 071, but I still keep my 640115, right? And I'm moving across platforms, right? And that it's an elementary example of interoperability. There are many examples where money moving is, moving around the USDD codes. So you need to think about data portability as a right of a data subject. That if I want to move with my information from service provider A to B, I don't need to be re-registering. I'll tell service provider A, I already have access to my information, and this is my information. Make use of that, and I can reuse it as needed. It also has its challenges, but it's something that you might have to look at. Moving on quickly, data controller and data processors. This is very important. And the first notice that Portras issued made almost everyone a data processor, a data controller, which is very unfortunate. Because, again, some of the things that we don't touch much in the guide, because it's now about the Act itself, is there are certain exclusions that should have been put in the Act, which I think are missing. Specific exclusion is if you're processing information for home use, personal use, if 30 people suddenly rock up at my house, I know there will not be 30 people coming to a party in an event, and I take down their details. Am I now a data controller? Maybe I'm taking down their details for purposes of tracing COVID and dealing with infection. Am I now a data controller? Because you said 30. But this was for purely home use. They were coming for a bride or for a wedding. Right. So there's need in this Act to actually distinguish. And I think as the interpretations and the guidelines come out, this will be, will be refined. Then also the compliance of the Act is important through and through. There's what is called an accountability principle. So you should not then say, oh, we complied with this part, but not with that part. No, it has to be compliance with the entirety of the Act. Because the issue with data is that data moves through a data life cycle. There's a chain that it follows. And it could be at any point of the chain that the violation happens. So you cannot say we complied when we collected, but we didn't comply when we stored, because the violation might happen at the storage, where you're keeping the data. You have done everything to ask of my approval when you're collecting, but you didn't store my information properly. That's part of the accountability principle. Then also the notification of breaches to Portras, which is very important. Then issues of automated data processing. Some of the key differences, I think this is critical to take into account, between a processor and a controller. Some laws use different terms. I think POPI uses responsible, or I'm forgetting the other term that they use. But it means basically the same. So the controller is the one who decides to collect. The initial decision that we are going to collect the information comes from the controller. Then the processor now is the one is given instructions to actually collect the information, right? The examples that I gave earlier on, Teleso asking a research entity. Teleso is the controller because they've decided to collect. The research entity is the processor. They would not have thought about collecting that information had Teleso not given the instructions. So very basic. You decide also the data purpose. What are you collecting the data for? That's the responsibility of the controller. The processor does not decide on the purpose. They just take the instructions and they collect. The controller also decides on the type of personal data, right? And they direct the processor to from whom the data must be collected. And there's value there. The controller might gain, and gain here is not monetary. It might be execution of a legal provision. It might be compliance of a legal duty. That's the gain. But the processor is not aware of the collection purpose. They actually need not know what the collection purpose is. What they need to know is that they're going to go and collect the information. Then the others is that does a legal duty exist, a contract, the controller makes decisions based on the data. The processor also will decide on data storage, because as you are collecting on behalf of a data controller, you are storing that information, right? And this is where I think a lot of being opaque comes into play, that we don't know many of the people who are storing information on behalf of many of the data controllers. And that is a problem, right? We know that Portras has a central database for registration numbers, but we don't know what else Telecel Econet is collecting and where their data centers are. It is an issue because the next time we might have all data breaches, etc., etc. Then as a controller, you also decide when the data is destroyed. So in some instances, the Act, I know that the regulations on registration of SIM cards talks, I think, of 5 or 6 years. Then after they should be destroyed, assuming that it's not being used or it's not being repurposed for specific compliance purposes. So these are the distinctions that we need to know about. But there are times when these roles can be fused, what we call joint controllership. And those are where the processor might extend their responsibility to almost becoming responsible for deciding the use. Or the controller extends the processor's responsibilities, making both the controller and the processor liable for controllership, and that's joint controllership. It's something that you need to take into account, particularly for multinational or big corporates, because you might have within your company an entity which is a processor and the controller, because maybe you've got 3 or 4 entities. So you've got an EcoCash, you've got a cassava, you've got a, another facility. But at that moment, the holding company might be the controller. And these are some processors all feeding to what the controller is seeking. And in those instances, you might also end up having joint controllership. I just gave these as examples of what data processing is, and you know that, the collection of your medical information is data processing. So when you walk into Lancelet, and I saw that with COVID, right? We're all rushing to Lancelet and I was asking myself, what are the measures or the methods of securing this information? Now that we are not necessarily I'm not so sure which level we are in, of a state of emergency or disaster, what have they done with that information? Because if you recall in some of the information, you're not only disclosing your suspicion of having COVID, but you're also disclosing some other underlying conditions, right? That's something that we need to talk about, in how that information has been kept. Has it been destroyed? Who is responsible for that? The Ministry of Health will be responsible for that because all these actors fall under them. Some examples again of data processing that we look at in the guide: video surveillance cameras in public settings. Right now we're talking of smart cities. I think Bulawayo might have moved in that direction. I'm not so sure whether in Harare it is, but some countries in the region, like Joburg, towns have got thousands and thousands of cameras. Almost every other few meters there's a camera that is there. Arguments is that is for public safety and security. Good, but also what happens with all that information that is being collected. So these are some of the examples of, that we touch in the guide. Moving on quickly, to regulate, what is my time? Because, lawyers are like pastors. We can, are like politicians, maybe let me say pastors because you might not believe in what I believe, but like politicians, when we have captured the audience like this, we can go the whole day. Yeah, we can go the whole day. 14 minutes, okay. So there are key issues in data principles that are in the Act. So if you look at part 4 of the Act, or it starts from part 3 rather, which talks of quality of data, all the way to generality and purpose. But there are also other principles that are again reflected in the Act, which also makes it a bit of a difficult to read and to follow, because you might actually have to be digging for them and not be specific. Unlike the GDPR as an example, just list, I think it must be Article 5, just list all of them in one go. Then there is specific reference to those principles as and when the need arises. But our Act is drafted differently, that there are few sections, then the other principles are listed throughout the Act. So these principles emerged from the 70s. I think it was 1973 when what was called the Health and Education Warfare Committee in the US was concerned with the proliferation of databases. And they thought, okay, what do we need to do to actually safeguard people's data? And they emerged some of those principles, and they've evolved over time, refined over time to be where they are right now. And I think with time they're actually going to be more than the 8 that they are. And it talks about accountability, openness, collection limitation. It talks about purpose specification, use limitation, security, data quality, you name it. I'm going just to give a few examples, I think 1 or 2 examples on these principles, so that at least you have an appreciation of what they mean. So I'm using purpose limitation here. That's what the one that I picked. So when data is collected, there's a purpose that is defined for that data. Right? That's the purpose limitation. So if you collect information for purpose of developing a voters roll, which is one of the examples we use in the guide, you cannot then use that information for purposes of distributing seed maize seed. We know that maize seed is distributed, but those are different purposes. When you collected a ZEC, your idea was for me to be on the voters roll, not for that same information to be used for ZEC distributing maize seed. 2 different things. So there's a purpose limitation, but I'll give a qualifier. So as an example, the examples that I use, nasal fluids, COVID, we are in the pandemic season. What's the original use? COVID testing. What's a compatible use? A compatible use is a use which is related to the initial collection and does not deviate from the purpose. That's a compatible use. So we then had that there is Delta, there is this variant. Where were they getting the information from? It's from the collection that they've done on the testing because of genome sequencing, right? So that's compatible use. Cell phone number for voter registration, compatible use, notifying you of a polling station. I registered and I gave you my cell phone number. So if you then send me an SMS saying your polling station is at Tomlinson Depot, they actually usually is a polling station there, that's where you're going to vote. That's still fine. But if it comes in and tells me something different, then that's a problem. Educational qualifications, those are in tertiary institutions. It can be used for accreditation or register of qualified professionals. Then I give what are incompatible uses now. And this is one of the things that we need to take into account. Nasal fluids for COVID-19 testing. Trading with medical insurance firms. If I then get a call from Chawasarira Medical Insurance saying, we got your information from so and so laboratories when you went to testing for COVID. I didn't consent to that. that is not compatible use. You're actually getting into direct marketing purposes, and I can object to that. Or voter registration, unsolicited political parties' messages, or educational qualifications, selling of third-party training programs. If I registered as a graduate of Spaces College, then the next thing I start getting messages from another service provider saying, we got your information from Spaces, we're offering this additional training or this offer additional opportunity for furthering your studies. That's not what I consented to. It might actually be incompatible because there's no marketing that is involved in there. So you need to take into account the differences on the use and limitation based on the principles. Quickly to the data protection officer. This is an individual appointed by the data controller and is in charge of ensuring an independent manner in compliance with the obligations provided for in this Act. Almost all of the institutions that are present here, at least from what I heard, you might have to be, at least start off by complying with the circular until POTRAS tells you otherwise. Because you want to err on the side of compliance rather than to be not. So err on complying, then at some point they'll probably say, well, the nature of data you're processing doesn't require a DPO to be in place, therefore you fall off. Public institutions, I would say public institutions by their very nature, because public institutions and government thrives on collection of information, that's a fact. Actually, information drives the provision of service delivery. So they should appoint DPOs without a doubt. And those that also process large-scale personal data, which could be something that I think POTRAS might have to look at in terms of defining who should have a DPO. Large-scale processing, multiple data subjects, the dynamic nature of the data that is collected, the presence of multinational actors and operators. If you have a customer base, maybe let's say 50,000, it basically means that so a certain threshold higher than 30, I think would be required so that you don't have unapprehended criminals roaming around because of the lower threshold. Then there is the guided notes that POTRAS issued on appointment of DPOs. So a DPO doesn't necessarily mean that you are hiring someone else separate. It can actually be someone who is within the organization. But they should have sufficient independence to actually say, boss, now this deal that you're getting into with this company is actually going to be in violation of our obligations. They should have that sufficient autonomy and independence to actually bring you to account within the institution. Because if they don't have, then it's pointless to have them in that position. You won't see this. This is the notice that POTRAS issued, and as you notice, it was under the Data Protection Act. This was before the correction that took place in the Government Gazette, but it's applicable as is the provisions of the Cyber and Data Protection Act. This has been touched on earlier on, but I think it's important that you should be aware of the powers and the mandate of the Data Protection Authority. A number of jurisdictions have single and combined, and I'll explain what I mean. Single in the sense that one institution is responsible for both freedom of access to information and protection of privacy. So South Africa is an example. The information regulator, when that regulator came into place, they removed the role that was being played by the South African Human Rights Commission, who were implementing provisions of the promotion of access to information prior, and is now subsumed under the information regulator. It's got its difficulties, got its challenges, but it might help for consistency. Then also issues of independence and accountability, that has already been spoken about. I'm not going to dwell much on that. We give examples in the guide of other jurisdictions. I think we use Kenya and South Africa in terms of the appointment processes as a comparator for you to see how others are appointed. And I hope in the fullness of time, as I'm concluding, that the executive and the legislature will be open to allowing POTRAS to hand over to someone else. Ideally, it could be a statutory commission. It doesn't have to be a constitutional commission. It can actually be a statutory commission or a statutory role, for as long as there is no semblance of conflation of responsibilities. Because right now, I think what we have is the trust deficit. It will be difficult to say Potras has got the PTC, the Post and Telecommunications Act. It has got the Cyber and Data Protection Act, and all the things that are in there that they have to deal with. It's an issue of building trust and confidence. And I think right now, it's a process. There might be a trust deficit on, can we actually entrust Potras with this, or we are making Potras a super regulatory agency, which can be problematic. Some of the things that need to be looked at, I think there are a number of laws that are in existence that I think need to be revisited. I know Nelly might be covering some of those. And I'll give a specific example. This act on section 4, which I know has since been corrected, it talks of it says this act shall apply to matters relating to access to information, protection of privacy information, processing and storage of data, wholly or partly by automated means, and shall be interpreted as being in addition to and not in conflict or inconsistent with the Protection of Personal Information Act. We don't have that act, and it's not going to come into place because that act would have been a repetition of this. I think this was also drafting related aspects that have to be taken into account. But I submit that this section should be amended to actually say that if there's any other law which is in existence or operational, to the extent that it is inconsistent with this act, then that act is void. To the extent of its own inconsistency. I think we need that provision because it then gives a sense of supremacy of this act. Right now, it's not clear. It's not explicit. It's implied. It's unlike when the Freedom of Information Act was passed. It basically says this is the act pursuant to Section 62 of the Constitution that is fulfilling this right of access to information. Then there are also issues to do with the linkages to the Freedom of Information and the Media Commission. I've already mentioned that you are going to be submitting an access of information request to the Zimbabwe Media Commission, which access of information request might have issues with this act. So it means these two institutions have to be talking. They actually have to create a memorandum of understanding and a memorandum of cooperation. Otherwise, you have ZMC ordering disclosure of information that is contrary to what Potras would have said, right? Because it might be in breach of this. Hence my submission that maybe a single entity is required or clear parameters of engagement. The other point is that the Act is silent around exclusions, journalistic privileges and artistic, but also home use. I think it's important to specify that because the moment that there is that specification, it eliminates and reduces your responsibility for things that might not necessarily be within your manageable interest to be focusing on. But right now, we are responsible for everything under the sun that relates to data, the way this act is structured. Then there's also an issue of security and sensitive information, which I think needs a longer conversation because the minister responsible for the Cyber Security and Monitoring Center, in consultation with the minister, this is section 11 of the Act, 11.4. The minister responsible for the Cyber Security and Monitoring Center, in consultation with the minister, may give directions on how to implement this section with respect to sensitive information affecting national security or the interests of the state. So there are concerns. I have concerns with how this is framed and how it might open up to abuse of personal information. So that needs also to be looked at. I've spoken about data subject rights, data portability, in particular in the digital economy. How do you move data across platforms and what safeguards are required there? Then the Act is also silent. I know this is a huge debate among lawyers on whether you have a comprehensive, you have a sectoral, you have a technology or you have a hybrid regulation. What you probably have is a comprehensive and hybrid, in the sense that you also need to specify technology designs that help you in protecting data. Remember that much of the data that we're talking about is being collected on digital platforms, right? So if you want to use manual means to deal with data collected on digital platforms, you're fighting a losing war. You have to specify, at least within the Act, that certain technical measures that my brother spoke about, such as privacy by design or default, is included in the Act, because it's proactive, it's not reactive. This is partly reactive, you know. It's embedded in the design. The point that I wanted to ask him is they're designing these tools, are they conducting privacy impact assessments, right? Because it's important to actually see that, yes, this tool is enhancing privacy, but it actually has got weaknesses. There are areas that we need to look at. We actually can allow someone to go and look at the code, because that's also part about transparency. I need to see the code behind the application, not just give me the application and say, oh, install this application, it will secure information. What if it's channeling information, you know, through a backdoor? We know of those things happen. It's not like they haven't happened, right? So the Act might need to look at also issues to do with, you know, privacy by design. I think let me end here. I've taken more than enough. Thank you.
You said you're not a lawyer, but I heard things like to the extent of its inconsistency.
I went to law school. So.
I suppose that's where, yeah, but it's typical lawyering. Okay, let's give you another round of applause. I think that was really interesting and really an in-depth presentation. Thank you so much for that. So I'll open it up for any questions. I think we've kind of had an overview. We've just gone through, and we've got the actual Act itself. And maybe let me do something while you're thinking, and preparing to exercise your democratic freedoms. So I'll ask possibly the chair to just come forward with the guide itself. I'll ask Titi to also come forward, and we just take a few minutes for some optics. With your permission, consent is always